So I'm glad everybody's kind of coming in for lunch. Again, my name is Chris Mayer. I'm one of the co-directors of the Richard Paul Richman Center for Business Law and Public Policy, and it's great to welcome you back to the Global Justice Forum. So this morning we had, I think, started from something that at least initially seemed a little more U.S.-centric approach of thinking about the subprime mortgage securities, although they tended to be bought around the world. We certainly moved to Europe and the UK in Libor, and now we're going to really think about an issue that affects almost all of us from a global perspective, which is looking at workplace standards in the global supply chain. And we are really lucky to have one of the foremost experts in this area and one of the people who is sort of most involved in these discussions and debates and has been for a very long time, well before some of the recent headlines that we've seen and some of the horrible events that have occurred in the last year or so. So I wanted to introduce Mark Berenberg. Professor Berenberg is a professor here at Columbia Law School and is somebody who has spent his life and career working on issues like this that are of great importance to all of us. So I wanted to introduce Mark, who is both going to chair the panel and I think get in more than a couple of words edgewise in participating as well. So welcome, Mark. Thank you very much.
Thanks, Chris, for that very generous introduction. So, yes, this is the panel that's going to address the question of enforcing labor standards in the global economy, and more specifically in global supply chains. We have some great panelists. Teresa Haas is with the Worker Rights Consortium, which is a Washington-based organization of about 200 universities that monitors factories around the world that produce collegiate merchandise, like Columbia sweatshirts. And Columbia is a member of this consortium. And I believe the WRC has created really the gold standard in codes of conduct for global factories and enforcing codes of conduct. The WRC and Teresa have been at the center of the public-private accord on workplace safety in Bangladesh. That's been on the front pages for the last few months. Jim Brudney is a preeminent professor of labor law. Jim's done the deepest research on the legal enforceability of private codes of conduct. He's also a member of the Committee of Experts at the International Labor Organization, which is the body that promulgates international labor law and supervises its enforcement and implementation. Though today Jim is not speaking in that official capacity. He's speaking as a professor from Fordham Law School. As Chris said, I'm a professor here. I'm director of our program on labor law and policy. I'm an advisor to the Obama administration on methodologies for measuring whether our trading partners, countries around the world, are complying with basic labor rights. I also served as an independent expert for the ILO in its first big research project on multinational codes of conduct in Asia and Latin America and North America. Now, the economic backstory of this panel, it's pretty familiar. In the last few decades, there are three big economic transformations that are relevant, and I'll just state them in highly simplified form. First, a lot of systems of production and distribution that once were vertically integrated, that is, they were done in-house within the administrative structure of a single corporation. They're now carried out through a chain of contractual relationships, that is, the firms vertically disintegrated. So, for example, a firm that sells running shoes call it Nike. These days might not make the shoes at all. The shoes are made in factories owned by third parties, so-called vendors, that might be headquartered, say, in Singapore, and the shoes might be made in factories in India or elsewhere. And the logistics for ensuring the flow of the shoes from the factories to retailers might be done by specialized logistics firms, not by Nike. So the running shoe company might produce not much more than a brand with some in-house design and prototyping capacity. So you can call this a production and supply chain or network, or simply supply chains. Second, we've shifted from a world driven by manufacturers to a world driven by big retailers and brands. So General Motors was once the core of the US economy with the biggest workforce, and distributors and suppliers danced to its tune. Now Walmart is the biggest employer, and its specifications of product design, quality, cost have to be met by manufacturers around the world. The retailers now hold the whip. Third, of course, is globalization, the liberalization of capital and product markets, the revolution in transportation, the containerization revolution. Things are put in boxes, put on ships, the boxes are put on trains or trucks. So supply chains can begin with production in low-wage economies that serve as export platforms, and the goods flow to the retailers and consumers in affluent economies. And the pressure on price points that the retailers or brands pay to factories is intense because of globalization. Global product markets are more competitive. Now, something else started in the 1970s and accelerated through the 80s and 90s, and that was the anti-sweatshop movement. A loose movement of labor activists, human rights groups, student organizations, religious groups, demanding decent labor conditions in the source countries. Conditions were and still are frequently horrendous. Widespread child labor, wages below 30 cents an hour, workers sometimes locked into debt bondage or other forms of forced labor, sometimes not getting paid at all for months or years. Hours longer than 80 or 100 a week, coercive, even violent supervision of workers, workers sloshing around in bare feet in toxic puddles, lack of fire exits, lack of paths to fire exits, if there are fire exits. And along with the activist movement, there were a series of media exposés. So we saw the rise of the CSR movement among global corporations, CSR, corporate social responsibility, and especially the rise of corporate codes of conduct, adopted voluntarily by the corporations, though of course under media and other pressures. Codes that required their supplier factories to comply with basic labor standards. So almost all brands and retailers now have these codes. And the codes are enforced by three categories of private labor auditors or monitors. Jim will tell us about other strategies, but the enforcement began with in-house managers, CSR departments. Then there was a turn to third-party monitors, for-profit or non-profit firms. There's a big industry now of labor auditing firms, sometimes offshoots of financial auditors. And then the rise of so-called multi-stakeholder initiatives, organizations run by different permutations of corporations, consumers, labor groups, human rights groups, university administrators and faculty, and so on. So the activist movement criticized the first two sets of monitors over their conflicts of interest. The in-house monitors, the third-party monitors chosen and compensated by the corporations whose codes they were enforcing. And the activists criticized many of the multi-stakeholder initiatives for their lack of genuine independence from the supply chains they were certifying. And so there's an intense debate, sometimes an intensely political or ideological debate over which modes of enforcing codes have meaningful effect on labor standards, and over whether the entire exercise of corporate codes and private monitoring is the way to go. So, our panel will address some of the key issues and arguments in the debate and some of the most recent developments. And we'll start with Teresa, who will tell us about the very timely and important developments in Bangladesh.
Thank you, Mark. Good afternoon, everybody. I want to talk to you today about, as Mark said, the growing fire and building safety crisis in Bangladesh and the strategies that are being used by labor rights advocates around the world to address not just the crisis in Bangladesh, but the broader problem of labor rights violations within the garment industry. And I want to start off by telling you about a building collapse that happened in Bangladesh at a garment factory that was producing for several major Western retailers. The factory itself was housed in a poorly constructed building that had had several floors added illegally onto the top of the building. And prior to the collapse of the building, workers in the factory noticed cracks in the structure, and they warned management that they were worried about the building's safety. The following day, workers were reluctant to go into work, but managers forced them into the building. And shortly thereafter, the building collapsed on top of them, killing many of the workers and injuring hundreds more. Now, the situation I've just described to you probably sounds to you like the incident that you heard about back in April, the collapse of the Rana Plaza factory building. But it's not. This is a picture of the factory that collapsed like a pancake on top of all the workers inside. It's a factory that collapsed in 2006, 7 years before Rana Plaza happened, virtually identical to the disaster that killed 1,133 people back in April. After the incident in 2006, after the collapse of Spectrum, brands and retailers expressed deep concern for the safety of workers at their factories. They promised that they would do everything in their power to improve the industry, to make it safe, and to ensure that a disaster like Spectrum never happened again. In fact, Spectrum was just one of a series of fire and building safety disasters in Bangladesh in 2005 and 2006 that killed more than 200 workers. And this elicited an international response. Consumers were outraged, the public was outraged, and so brands made promises and commitments that they would do better and that they would improve conditions in their supply chains. H&M, the largest buyer from Bangladesh, announced that it would begin to conduct unannounced safety inspections at its supplier factories, and that it would ensure that factory doors were kept open and emergency exits would be unlocked. In a meeting in 2011, shortly after a fire at a Gap and Walmart supplier in Bangladesh in which 29 workers were killed, Gap and Walmart acknowledged that most factories would need, quote unquote, very extensive and costly modifications, but the companies refused to pay a dime in order to carry out the acknowledged modifications that were needed. And so as a result, despite public hand-wringing from the brands and promises to improve conditions, the deaths continued in fire and building safety, fires and collapses, and between 2010 and 2013, more than 1,600 workers were killed in these preventable tragedies. The deadliest by far, of course, was the collapse of the Rana Plaza building back in April, which was the worst factory disaster in the history of the garment industry. And in fact, 3 of the 4 deadliest disasters in the history of the industry took place within the past year. Anybody tell me what the 4th deadliest disaster was in the history of the garment industry?
The New York Triangle Fire.
The Triangle Shirtwaist Fire more than a century ago in New York. And so it appears that we really haven't made that much progress. All that we've really done is we've outsourced the tragedies from this country to somewhere else in a place that is further away and easier to hide. It's a photo of the Rana Plaza collapse. And so I want to step back for just a moment and talk a little bit more about the structure of the global garment industry, the problem of sweatshop labor, and how the situation that we have now in the global garment industry was created. For nearly 2 decades, apparel brands and retailers have sought to evade responsibility for conditions in their supply chain, and in order to do so, they have created an ever-expanding system of subcontracting and outsourcing that is designed to put as many layers as possible between the brand's reputation and the workers making its clothes. What this system does is that it allows brands and retailers to exploit the system to their advantage and pit their suppliers against one another to achieve the lowest possible price. In the global race to the bottom, factory owners understand that if they cannot offer the lowest possible price and the quickest turnaround time, they will lose the orders and it will go somewhere else. The easiest way, of course, for a factory to cut its prices and to offer Walmart a lower price every year is through the most flexible cost in a factory, which is labor. Now, you might point out, rightly so, that many of the countries, in fact, most of the countries where apparel is being produced have excellent labor laws on the books, in many countries better than what we have here in the US. And yet, local governments often lack both the resources and the political will to enforce the law. They understand that it is the low costs of production that result from lax enforcement that actually attract foreign investment, and that to enforce the law would really be bad for business in their country. So the effect of the current structure is to really encourage a culture of lawlessness and drive workers into even greater poverty by ensuring that they are paid the minimum or sometimes below the minimum wage, face increasing unemployment stability, work excessive overtime, and fall greater and greater into debt. And so the system that we have today, in which exploitation is the norm for the production of garments that are sold here in the US and in Europe, is not an accident. It's not a mystery why this happens. In fact, it is the inevitable conclusion of the global race to the bottom that Gap and Walmart and others have perfected over the past 20 years. So the consequences of this system manifest themselves particularly poorly in Bangladesh, with an apparel sector that is defined by an utter disregard for even the most basic safety systems, and made up of factories that are so grossly unsafe that if they were located in this country, they would be shut down tomorrow as a threat to human life. Bangladesh is also the country in the world with the lowest wages for workers in the garment industry, who earn 18 cents an hour, or just $37 per month. And it's the most dangerous place in the world to be an apparel worker. And it is for exactly these reasons that Bangladesh has become the second largest producer of apparel after China and will likely eclipse China in the next 5 years. And brands and retailers have poured orders into the country. And in fact, in the months since Rana Plaza happened between April and now, exports of garments from Bangladesh have increased. And so the industry is really getting exactly what they pay for in Bangladesh. At the same time, brands and retailers are telling the public, telling consumers that they are doing everything in their power to ensure that workers are safe, and that they have put in place robust and highly effective systems to ensure safe and responsible practices by their suppliers. But in fact, all of the factories where major deadly disasters have occurred had been recently audited and certified by multiple industry auditing schemes, which failed to detect and remedy the problems that led to so many deaths. It's clear from these tragedies that corporate self-regulation has been an absolute failure at protecting the lives of workers and improving the industry, which really should come as no surprise if you look at the way that corporate monitoring is carried out. Most industry auditors lack the necessary expertise to monitor all but the most basic issues, and they are paid either directly or indirectly by the factory's customers, and they are therefore under tremendous pressure not to report too much bad news. In Bangladesh, a country that is known for its deadly fire and building collapses, brand inspections do not even look at fire and building safety issues. And because the system lacks any type of transparency, problems that are identified are not communicated to workers or to other stakeholders. At the same time, even if these problems are reported, the brands and retailers are not under any obligation to pay for or to make improvements at their supplier factories. And yet brands have been claiming for years that they have these systems in place to protect workers' lives. After the Tazreen Fashions fire last November on Black Friday at the Walmart factory, Walmart CEO Mike Duke made a public statement saying that Walmart would not buy from an unsafe factory. Shortly after Mike Duke made this statement, there was an internal memo from Walmart's head of labor rights compliance that was circulated. This is from the person, by the way, who was responsible for making sure that Walmart does not source from an unsafe factory. This memo stated, fire and electrical safety are not currently adequately covered in ethical sourcing audits. And so what this statement tells us is that it is not just the supply chain practices, but also the negligence and the dishonesty of brands and retailers that has left hundreds of workers dead, and more deaths are virtually certain. In fact, there was a fire just on Monday at a Walmart factory that killed 8 workers. So what is needed? How can we prevent the future tragedies that we know are inevitable? What we need to do first is make a radical shift away from voluntary self-regulation by the industry to binding agreements between companies and worker representatives. And in Bangladesh, this has taken the form of something called the Accord on Fire and Building Safety. This accord calls for an industry-wide program of renovations and repairs to make sure that unsafe factories, which is what makes up the bulk of the Bangladesh garment industry now, are made safe. The reality is that these renovations and repairs will be extremely costly, and that factories that have for years been squeezed on price will not be able to afford the renovations and repairs that are needed. And so buyers have to be willing to offer financial support to make those changes. They must also accept the premise that safe factories and good factories cost more. It costs more money to produce under safe, better conditions than under unsafe, worse conditions. And there must be a public, transparent program in which detailed safety audits are carried out at these factories. And most importantly, workers must have a voice in the monitoring as well. And so all of these commitments are called for under the Accord for Fire and Building Safety. There will be independent inspections with full public reports being made available within the first 9 months of the program. Brands and retailers must require all of their supplier factories to carry out the renovations and repairs that are called for subsequent to the fire, building, and electrical safety inspections. Factories that refuse to comply with the renovations and repairs that are recommended will lose business. Factories, on the other hand, that agree to make the changes that are needed will get commitments of long-term orders at the same volumes or higher volumes than they had previously been receiving. Workers will play a central role in ensuring that these commitments are carried out through the formation of occupational health and safety committees and through the formation of labor unions, so that they can play a central role in ensuring that factories are made safer. It is really the first binding agreement within the contemporary apparel industry in which brands are committing to pay to improve conditions and are actually aligning their sourcing decisions with the labor rights obligations that they have. The status of the Accord right now, there are more than 80 companies that have signed on to the program from 16 different countries. The largest by far is H&M, which is the largest buyer from Bangladesh. Inditex as well, which owns the company Zara. It's the world's largest fashion retailer. 2 European companies, Carrefour and Tesco, which are actually the second and third largest retailers in the world. PVH, which owns Calvin Klein, Tommy Hilfiger, Bass, and Izod, and is also the largest seller of shirts in the world. And most of the major apparel retailers in Europe have signed on, as well as many large companies from the US and Canada. And there are about 1,600 factories and more than 2 million workers that are represented and covered by this accord. So what will happen now, there has been a list of all of the factories that are covered by the accord has been released and made public. That is the first time ever that such a list has been made publicly available to workers and their representatives. There will be independent inspections at all of those factories within the first 9 months. And then there will be an immediate process of renovations and repairs to fix the most urgent hazards. And we know that there will inevitably be challenges. This is a program that is a dramatic departure from the way that the industry has operated, but the legally binding nature of the program will allow us to ensure that companies live up to the obligations and agreements that they've made. I'll finish up there and happy to take questions at the end. Thank you.
Thanks, Teresa. So Jim is going to talk to us now about the extent to which codes are legally binding and alternative strategies for enforcing them.
Thanks. First, I would like to thank the Global Justice Forum and the Richman Center, and especially Mark Barenberg, who is truly a leader in this field, for having me speak today. Now, as you've heard, over the past several decades, global corporations have adopted codes of conduct that declare their commitment to respect fundamental workers' rights. Many of those codes specifically promote corporate respect for rights to freedom of association and collective bargaining. These codes don't require adherence to specific labor regulations or standards in a global setting, and in practice, as we've heard, the corporate record on voluntary compliance has been disappointing. Indeed, that record has been embarrassingly disappointing with respect to low-wage industries like apparel, shoes, and toys, where a global supply chain of contractors effectively controls labor conditions and exploits workers, often ruthlessly so. My article, of which you have some excerpts in your handouts, is divided, like Gall, into 3 main parts. I want to focus today on a central observation or direction that emerges from each of the parts. In the empirical part of the article, which is the part that I don't think you have a piece of, I review the freedom of association provisions of some 30 corporate codes of business conduct or business principles, based on what I gleaned from the careful wording and glossy website designs that they make available for public consumption. I'm talking about Adidas, American Eagle, Hanes, IKEA, Nike, Tesco, and about 25 more. I found that although almost every code has some pledge of allegiance to freedom of association, there are a range of differences in formulation. I was somewhat surprised by the extent of variation among these multinational corporate codes, but it prompted me to think about what might constitute best practices from the standpoint of a formulation on paper or the web, if you will. And I refer in this context to the code from Nestle's as a kind of gold standard in 2 respects. First, Nestle's corporate business principles explicitly set forth a commitment to adhere to and respect freedom of association rights as set forth in the core ILO convention addressed to that subject. And by the way, I'm going to be talking specifically about freedom of association, but core rights like child labor, forced labor, non-discrimination would equally fit this discussion. The embrace of ILO standards reflects a commitment to something more affirmative and protective than labor laws in the United States and many other countries, which, as implemented, are often characterized by weak remedies and long delays. Second, the Nestle Code states unequivocally as follows: where our principles and regulations are stricter than local legislation, the higher standard applies. That statement preempts any inclination to invoke respect for local laws and customs as shields against compliance. I would add that Nestle does not make that same latter commitment with respect to its code for suppliers, only its code for its own employees. And I regard that deviation as a flaw, not just a blemish. Other corporate codes are less assertive than Nestle on both of these 2 items. They refer to ILO conventions, specifically including freedom of association, in generalized and aspirational terms, and they accept the restrictions imposed by local laws, usually noted as respect for local government or culture, as an integral element of their position on child labor or freedom of association. I want to suggest that something like the Nestle standard, applied especially to suppliers, is a goal worth striving for in this arena. It's important to identify a level of verbal or written commitment to a standard like freedom of association that employees and interested third parties can then seek to use as a firm standard or benchmark. The reason why I think this matters, particularly for freedom of association, more than has previously been addressed, is that we face a kind of a catch-22 with respect to the concept of self-regulation or co-regulation through corporate codes. Most observers agree that codes can be effectively monitored and meaningfully enforced only if workers play an active internal role. But without an unqualified commitment to freedom of association, very few workers will ever play that role. Even with a firm commitment, I think code compliance will require options for outside private enforcement. This is because employees' fear of reprisal, especially employees buried in low-wage jobs on the bottom rungs of global supply chains, is an inevitable dimension of their status. That's one reason why I see better prospects for private enforcement through litigation by consumers and investors who are not burdened with the economic dependence of an employment relationship. So in short, if freedom of association is to be enforceable at all, it has to be expressed in terms that reasonably lend themselves to accountable expectations, that are not unduly aspirational or vague. Now, in the third part of the article, I developed the critique of corporate codes as too often reflecting sort of cosmetic efforts at self-promotion, efforts that engender goodwill and fend off public or regulatory criticism without notably improving labor standards. Many observers, as Teresa has pointed out, regard these codes as largely ineffective, especially in low-wage industries like apparel and shoes. And in practical terms, they aren't. The codes are not enforced rigorously from within. They're not monitored for performance by an independent body. And they don't include sanctions for noncompliance. At the same time, I don't think it's helpful to demonize the codes or their promulgators. Even when aspirationally phrased, they can lead to some progress. And there are plenty of corporate actors operating in good faith and trying to push the envelope of effective monitoring and enforcement. In theory, a compliance approach that's based on government labor inspectors and public enforcement would be cleaner and more efficient. But as Teresa noted, for most, if not all countries in the global supply chain, the absence of financial resources and sustained public will are major impediments to such an approach. I therefore take as a given that internal compliance models are a long-term, if not permanent aspect of the legal culture with respect to basic labor standards compliance. At the same time, I think there's a potential important role for private enforcement through courts and agencies as a complement to internal monitoring and enforcement. I draw an analogy here to whistleblower laws in the United States because those laws track the same set of challenges, agreed upon norms of corporate conduct that are increasingly under-enforced due to the decline of unions and the scarcity of government resources. There are two possible kinds of whistleblowers. Internally generated whistleblowers, or whistleblowing comes from employees. Externally generated whistleblowing emanates from other actors like consumers and investors, who also have an economic relationship with the corporation, but who don't face the chill of possible reprisal or the subtler limits imposed by internal norms of silence and conformity. So the last part of the article is perhaps its most original contribution, which is trying to evaluate what is now a series of clearly long-shot causes of action. And this may seem like a classic academic thought experiment, or put differently, an exercise in futility. Apart from my belief that at least some of these approaches hold promise, I am reminded of where United States law was at in the early 1970s with respect to tort and contract-based exceptions to our norm of employment at will. Not many American judges or even academics in 1973 thought that a public policy exception to employment at will would be adopted in 49 states, or that personnel manuals would come to be viewed as unilateral performance contracts absent a clear and prominent disclaimer. By developing and intensifying the discussion about doctrinal possibilities, I think we can encourage attorneys and perhaps judges to take seriously the prospects for complementary private enforcement. Now, in the article, I talk about I imagine 8 different possible causes of action. 3 for employees, 1 for consumers, 4 for investors. And I think many of them are even beyond long shots. And I just put them out there so that people can think about them. But I want to talk about 2 that seem at least closer to plausible. It's important to bear in mind that being an effective deterrent here does not require that plaintiffs win these lawsuits every time they bring them. If these causes of action survive motions to dismiss, they'll often compel corporate concessions in the form of agreements to negotiate. Indeed, the record on proxy proposals under Section 14A(8) of the Securities Exchange Act confirms that when the SEC declines to exclude a proposal, corporations increasingly negotiate language that gives the complaining shareholders a certain amount of what they want in terms of tighter monitoring of corporate control, of supplier activity, if you will. So first, let me address a possible cause of action by consumers for false advertising. When a corporation in its code of conduct promises to abide by the dictates of Convention 87 and to require that its suppliers do so as well, some consumers are likely to rely on those statements when determining which goods or services to purchase. The issue becomes whether, in appropriate circumstances, an action for false advertising can be brought by or on behalf of consumers, and relatedly, whether such an action should be limited by First Amendment considerations. Over 40 states have laws prohibiting statements or prescribing statements that the speaker knows or reasonably should know to be false or misleading when such statements are made with the intent to dispose of goods or services. In the leading case of Kasky versus Nike, the California Supreme Court in 2002 held that false statements about its employees' labor conditions made by Nike in letters to its customers were actionable under state law to prevent consumer deception. Are corporate codes commercial speech is the first question. One can argue that they are, given how they are packaged in a glossy advertising-type format with elaborate graphic design and colorful illustrations. Their message is a recognizable form of puffery to the general public, describing the virtues of their labor standards operations. Indeed, in contrast to Nike's press releases and letters in Kasky, where the company was defending its labor policies against public criticism, corporate codes seem directed not at public opinion makers as part of an ongoing exchange, but rather at the commercial audience of consumers and investors who want to either buy or invest in socially responsible terms. When Nestle or Disney or Nike extols their commitment to high labor standards on their websites as a visible element of corporate identity, they're invoking social responsibility as a marketing tool to boost product sales. This form of unilateral self-promotion would seem to qualify as a type of advertising, albeit one focused on the attractiveness of a corporate image rather than a corporate product. Are the codes actually or inherently misleading? That may depend on variable standards under state law. Whether reasonable consumers are likely to be deceived will require a careful reading of both state statutes and code language. Is a corporation claiming to engage in the labor standards practices it states are necessary and proper, or is it merely espousing policy preferences it aims to achieve? Provisions pledging freedom of association protections might be viewed as too general or aspirational to be capable of deceiving a reasonable purchaser. On the other hand, an unequivocally clear code commitment to respect freedom of association regardless of local laws could be seen as deceptive if a corporation sources most of its goods in a country like China that refuses to accept independent labor organizations, or if a corporation's factory supervisors regularly punish employee attempts to form unions, or if a corporation makes no serious effort to monitor the repressive anti-union practices of its suppliers. Finally, should state laws regulating the truth or falsity of corporate code representations receive heightened First Amendment scrutiny? It can be argued that even if the codes are economically motivated, and even if they're packaged in a public relations type format, a corporate presentation about labor conditions invites public reaction and response to an ideologically framed message. As such, codes are contributing to debate on a matter of public concern, and efforts to regulate their content should be reviewed more rigorously than typical commercial speech. However, unlike the back and forth exchanges in the Nike case, which troubled a number of members of the Supreme Court in separate opinions, corporate codes are unilateral website presentations. Rather than initiating or contributing to public debate, they're more accurately described as efforts to declare that companies promulgating them rely on human rights-friendly or sweat-free manufacturing processes. It's well settled that states and the Federal Trade Commission may regulate the accuracy of corporate declarations about products being made in the USA, even though the country of origin issue is a matter of ideological and political controversy. It's hard to see why corporate code declarations about freedom of association or child labor or other workplace standards should be analyzed differently from a consumer protection standpoint. Let me talk more briefly about the second possible cause of action for failure to monitor suppliers in response to shareholder or investor claims. In a case called Caremark, which is a 1996 Delaware Chancery Court decision, shareholders argued that the board of directors' failure actively to monitor corporate performance subjected the corporation to substantial legal liability. The court held that a board of directors has a duty to ensure that appropriate information and reporting systems are established by management, systems that are reasonably designed to provide to senior management and to the board itself timely, accurate information sufficient to allow management and the board to reach informed judgments concerning both the corporation's compliance with law and its business performance. In doctrinal terms, it would seem, in principle, that investors may bring Caremark claims based on the corporation's inadequate monitoring of known business risks. Although a number of post-Caremark decisions have involved challenges to monitoring and compliance programs in the context of possible civil or criminal liability, the Caremark test envisions holding directors accountable for oversight failures related to business performance as well as law compliance. To be sure, it is very hard to prevail on a Caremark claim under Delaware precedent. The alleged failure of oversight must be pleaded with particularity regarding the inadequacy of the board's monitoring mechanisms. These allegations should reflect what amounts to a conscious decision by directors to ignore their oversight responsibilities. Still, the Delaware courts have made clear that there are paths to recovery under Caremark. A decision to ignore oversight responsibilities might be predicated on a board of directors having not created an important supervisory structure, such as a monitoring committee, or on the committees having failed to meet after having been formally constituted. In addition, and importantly, the good faith oversight obligation requires that directors pay appropriate attention to information enabling them to spot red flags. As explained by one corporate scholar, red flag situations pointing to a flaw in internal compliance system may arise due to a single dramatic incident or a series of more modest episodes over a period of time. Shareholder allegations of directors' failure to spot red flags may be sufficient to survive motions to dismiss in appropriate factual settings. So how might ignoring red flags or that theory apply with respect to labor standards codes? Assume, arguendo, that it is well known in the global apparel or athletic shoe or toy industries that suppliers frequently maintain duplicate books to deceive auditors about wage and hour irregularities, and that they script or intimidate workers to avoid detection of their refusal to respect child labor standards or freedom of association standards. A corporation may be ignoring red flags when it continues to rely on the same flimsy monitoring approach when, for instance, they direct managers or allow managers to conduct only 5% of performance audits unannounced, although it's widely known that unannounced audits yield more accurate and complete information. Likewise, it may become a red flag problem if directors refuse or resist proxy proposals to strengthen their own monitoring and enforcement programs, claiming that those programs absolutely don't need strengthening, and then something comes up. Let me stop there and turn it over to Mark, because I think I've probably opened enough can of worms.
Okay, thanks, Jim. So Teresa and Jim have been talking primarily about contractual and judicial mechanisms for enforcing labor standards. And I want to give you a quick overview of a mechanism controlled by the White House, a mechanism that's come into play in important ways in the case of Bangladesh. It's called the Generalized System of Preferences, known as GSP. And the backstory to the GSP is the World Trade Organization. The core rule of the WTO is the most favored nation principle. If the U.S. imposes a certain level of tariffs on auto parts or cell phones or T-shirts from, say, South Korea, we can't impose a lower tariff on identical kinds of goods imported from, say, Indonesia. But the WTO offers countries an exception to the most favored nation rule. The U.S. and other countries can grant lower tariffs or lift tariffs altogether for goods coming from developing countries for the purpose of promoting economic development in those countries. So the United States and the European Union have taken up that exception and give low-wage countries special exemptions from tariffs, and those exemptions are called the Generalized System of Preferences. But the U.S. Congress says to the President, you can only grant these special trade privileges to low-wage countries if they're taking steps to comply with a list of so-called internationally recognized worker rights, as well as other rights like intellectual property rights, or if a country abets terrorism or expropriates U.S. property, and some other preconditions. And the President can withdraw previously granted privileges if he finds that a country lapsed in its compliance with the basic worker rights. The GSP legislation authorizes any interested party to petition the President to withdraw benefits. The petition first goes to an interagency committee called the Trade Policy Staff Committee, TPSC. But ultimately, it's a White House decision, since it's a big political step, obviously, to impose sanctions on another country. So there's no standing requirement. Any labor rights or human rights or group can file a petition. And there's no case or controversy requirement, right? So the GSP has this interesting jurisprudential feature, right? In a typical legal case, we lawyers are pretty accustomed to analyzing whether a court properly defined the elements of a right or of a claim, whether fair process was afforded the parties, whether the remedy for one party or a discrete class of plaintiffs was well crafted. But under the GSP, the question is whether an entire set of legal institutions, all of the country's institutions, resources, personnel, fora, for enforcing a broad set of multi-dimensional rights across an entire labor market are adequate in some meaningful sense, or whether a country's taking adequate steps to ensure that the rights are enforced across the entire labor market. And GSP is equally unusual in a pure political or ideological sense. The common wisdom, which is accurate, I believe, is that the US is the leading global force for free markets, including for liberalized or flexible labor markets, for so-called structural reforms, which means, among other things, weakening labor unions and protections for individual workers. And that foreign economic policy is known around the world as neoliberalism or the Washington Consensus. But with GSP, we see an instance of what we all know, which is that a government is a complex, sometimes self-contradictory or internally contradictory animal. So our dominant policy around the world is the deregulation of labor markets and the weakening of labor unions. But we also have this statute on the books that requires the president to use economic sanctions to impose tariffs on countries that fail to regulate labor markets and protect labor unionism. And it's an interesting puzzle, bit of a puzzle, that the US was out in front of the European Union with this mechanism, right? In its foreign economic policy, at least before the sovereign debt crisis, the European Union emphasized the export of its so-called social model, right? An economic system that combines markets and social solidarity, including strong labor rights. But the US put labor rights conditionality in its GSP well before the European Union, and the US uses the GSP sanctions much more often than the EU. Now still, because the GSP is our secondary policy, promoting free labor markets, flexible labor markets is our dominant policy, GSP isn't enforced consistently or rigorously. Presidents tend to use GSP against our geopolitical enemies and not our friends. The GSP statute itself explicitly authorizes the president to set aside the labor standards issue in the name of US economic interests. And the courts have ruled that the president's decisions about using GSP to penalize a country or not are non-justiciable. So we don't really have a jurisprudence on this interesting question I mentioned a moment ago, how to determine whether all legal institutions of a country are taking adequate steps to enforce several complex rights across the entire workforce. But there's interesting work being done in the Obama administration to develop a methodology that would make that determination consistently and uniformly and transparently for each of our trading partners. Disclosure, I'm leading that, that project. The administration, we were working on a composite index of the kind that sprouted up on so many domains of international law, right? The UN's Human Development Index, the indices of corruption or sustainable environmental policies or public health and so on. But still, presidents in the past have used GSP sanctions on dozens of occasions, and the sanctions have, in many cases, had positive effects from the standpoint of improving labor standards. Even just a GSP review of a country, even just filing a petition without any sanctions imposed by the US can trigger significant improvements for fear that the country will lose access to the enormous American consumer market. So we see countries working with the International Labor Organization in the wake of a filing of a petition or a review or sanctions, getting countries to end or at least diminish the worst abuses like assassinations of labor union leaders or forced labor. but in some cases even more dramatic effects, contributing, if not being the dominant cause for the ouster of labor repressive dictators and opening space for democratic governance. In small, low-wage countries, the economic and political elites, they sit up and take notice if they face the loss of the U.S. consumer market for their businesses. One of the most dramatic examples is the case of Chile. Right after the Pinochet coup in the 1970s, the right to organize unions and bargain collectively was repealed. Union leaders were tortured and murdered in unimaginable numbers. The Chilean political and economic elite could live with being a political pariah, but they panicked when their economic foundation as an export economy was threatened by the denial of GSP. And it's no question that the GSP softened up the business community's support for Pinochet, and it was one genuinely important factor in the return to democracy and labor rights. A similar story can be told in Guatemala in the 1990s. An earlier period in Bangladesh, Senator Harkin pressed for a ban on imports made with child labor, and there was a threat of GSP sanctions as well, and that threw the Bangladesh garment industry into a sense of real crisis. And Bangladesh ultimately agreed to allow monitoring teams from the ILO and UNICEF to come into the country and ensure that children were moved out of the factories and into schools by tens of thousands, hundreds of thousands of children. And the U.S. Department of Labor paid for the program. And that case points to an important feature of GSP. It's not just a stick. It's really a system of carrots and benchmarks. When the U.S. withdraws GSP benefits from a trading partner, the U.S. typically articulates the steps the country has to take incrementally to regain the lower GSP tariffs. And that's exactly what's going on now in the U.S. Stance toward Bangladesh. So last June 2013, the president suspended special trade benefits on imports from Bangladesh after the horrific events that Teresa described. In a way, the U.S. is playing bad cop, and the EU is the good cop. The EU announced it wouldn't withdraw GSP benefits from Bangladesh, but would stay engaged. The EU instead entered into a three-way compact with the ILO and the government of Bangladesh to continuously improve labor rights and factory safety. Although just last week, the EU Trade Commissioner issued a pretty harsh statement saying Bangladesh, we better see some progress, some real progress on the ground. But even President Obama, the bad cop, issued an action plan when he suspended trade privileges, special trade privileges, and said the U.S. would work with Bangladesh and with the ILO and the European Union to help it improve its record in order to restore GSP benefits. And the action plan says Bangladesh has to meet certain targets for increasing the number of labor inspectors and fire and building safety inspectors, improving the training of inspectors, increasing penalties for violations of labor standards, assessing the structural safety of factory buildings, closing unsafe factories, creating a publicly accessible database of all factories, all building inspectors, all inspections as well, all violations, creating hotlines for workers to anonymously report violations, and so on. And there's an interagency hearing in the United States scheduled for December to evaluate whether Bangladesh is making progress. Now, the truth is that the GSP suspension by the U.S., it appears largely symbolic in the Bangladesh case because GSP benefits apply to only a very small share of imports from Bangladesh. The garment sector had not been getting duty-free treatment, so it's not directly affected by the suspension. So the sectors that are directly hit are in things like tobacco, porcelains, and plastic products and others. Just a small percentage of imports from Bangladesh, about $70 million worth compared to $5 billion in total exports to the US. So it might seem largely symbolic, but it's not only symbolic. It is an important shaming mechanism. It's an extreme embarrassment for Bangladesh. It's a threat that more sanctions might be on the way. The European Union good cop might turn into a bad cop if we don't see results. And even more important, the US has been negotiating a huge positive incentive for Bangladesh, if it does the right thing, duty-free treatment for the garment industry. And also very important, it's a signal to the private sector. Multinationals, they're a bit more hesitant to enter a country, to source from a country where there's such bad news that could stain their brand, where there's such authoritative official proclamation of bad conditions. Disney has already pulled out of Bangladesh. And I think it's probably no coincidence, Teresa might know better than I the politics of this, but that European retailers, have rushed to support the accord, since the EU's GSP does give duty-free treatment to garments made in Bangladesh. The EU GSP has a policy of ending tariffs on everything but arms. So European retailers would take a bigger hit if the EU were to withdraw GSP privileges from Bangladesh than the hit the US retailers took from the suspension. Since as I said, the US hadn't given privileges to Bangladeshi garments in the first place. Or conversely, if an authoritative body like the ILO or the US government gives a seal of approval to the labor rights record of a country, then multinationals feel more comfortable about sourcing from that country. It provides at least some shelter against activist criticism or some grounds for rebuttal against media exposés. So GSP tends to work in tandem with supply chain management and multinational sourcing decisions. It leverages private sector action. And it leverages the action of so-called transnational advocacy networks, that is labor rights activists, human rights groups, consumer groups. Our trading partners, labor unions and labor advocates reach out to US groups that can file GSP petitions in support of their domestic campaigns. So I'll conclude by just reiterating the paradox I mentioned earlier. The US government may be one of the strongest political forces for deregulating labor markets around the world, but it's also one of the strongest political forces for promoting labor standards, even if the former is the more persistent and intense policy. The US government at least occasionally puts some powerful economic incentives behind the international labor law announced by the ILO. Okay, so now we want to open this for discussion and Q&A. Maybe I'll ask Teresa first to elaborate on the point I was making that GSP the withdrawal of GSP privileges, even though it affects such a tiny segment of exports from Bangladesh to the US and doesn't affect the garment industry itself, nonetheless has a significant impact. And Teresa's just spent a month in Bangladesh and has a sense of this.
Thanks, Mark. Yeah, so I would just point out that the GSP process and the suspension has been incredibly effective in Bangladesh. It's also been a terrifically slow process on the part of the U.S. government. The suspension that was granted in June was in response to a petition that had been filed by the AFL-CIO in 2007. So it is by no means a quick process for suspension or revocation to happen, but it has already had a really tremendous impact for many people in Bangladesh. I'll just mention two examples. The petition that was filed by the AFL-CIO originally in 2007 was amended in 2010 after criminal charges had been filed against two prominent labor leaders in Bangladesh. The charges were filed in response to a series of massive worker protests in June of 2010 in Bangladesh over the country's minimum wage. And basically, the government, in an effort to retaliate against and prevent further worker protests, filed multiple fraudulent criminal charges against two main labor leaders in the country. There were documented alibis for both individuals in all of the charges that were filed. Human Rights Watch did an extensive report documenting the reasons why the charges were baseless. But nonetheless, the charges stood until 2013 when they were dropped, just around the same time that GSP was revoked by the US government. Simultaneously in 2010, at the same time that the charges were filed against these two labor leaders, one of their organizations had their legal registration with the government revoked. The Bangladesh government decided that they were no longer going to allow this particular organization to operate legally. It froze all of their assets, and they have essentially not been able to operate for the past 3 years. Almost immediately after the GSP was suspended back in June, the organization received its registration from the government and is now able to operate freely, is now able to access their bank accounts and their assets. So those are just two very small examples of the improvements that have happened just in the very short time that has passed since the GSP for Bangladesh was suspended. There is a whole roadmap that the US government outlined of things that the Bangladesh government has to do to get those benefits back. On a number of other things, there has been little to no progress. There will be a review, as Mark said, in December, the 6 months point, to see whether or not the government will get GSP back. Remains to be seen what the US government will think of what progress has been made, but I think at least in the very short term, it's had real meaningful impacts for a number of really incredibly strong and important organizations in Bangladesh that have done some of the best work that I've ever seen in defending and protecting the rights of garment workers in that country.
Hello, thank you to everybody. And my name is Stefano. I'm a personal injury lawyer, plaintiff lawyer from Turin, Italy. And I think I have a question for you all, which is, what is the status of the redress system for these victims, the victims of these accidents? What about compensation and lawsuits on behalf of those who were killed in the Rana Plaza building and the others?
Good question. So Rana Plaza, the Rana Plaza collapse happened in April. There was no discussion or talks about compensation at all up until the middle of September, in which there was a meeting that was convened by the ILO in Geneva to talk about compensation for the families of the victims that were killed in the collapse, and also for the families of the victims that were killed in the Tazreen Fashions fire back in November, a factory that was primarily producing for Walmart. There were 30 brands from the US and Europe that were implicated in those two disasters. They were all invited to attend and discuss a compensation package for the families. Of the 30 brands, 9 showed up and agreed to pay into some type of compensation fund. The details of that fund have not been worked out. It will be based on previous compensation schemes, primarily that were developed around the collapse of the Spectrum factory in 2006 and are based on ILO Convention 121, having to do with basically providing compensation in the amount that a worker would have been reasonably expected to earn over the rest of their lifetime. So I don't have any sort of, I can't give you any concrete numbers at this point. What I can say is that those compensation talks are happening with a small handful of companies that have agreed to pay their obligations. And we hope that at some point in the near future, numbers will be published in terms of what companies are agreeing to pay.
I can follow through. You said that ILO standard compensation is taken into consideration, but my current question is, we are talking about potential American, European, and Canadian defendants. So why is this the average compensation which is taken into consideration is the ILO standards, which I don't know, and not the American standards of compensation or Italian standards of compensation?
And I think that's an excellent point, and I would ask that same question to these companies. I would ask them why they couldn't even bother to show up for the discussion. I mean, maybe Mark or Jim can comment on the legal basis for this, but there are no legal bases on which companies can be held to those standards for compensation in this country for their suppliers and workers of their suppliers overseas. There's nothing obligating them to do that.
Yeah, I mean, I'm not sure I have anything to add in terms of there is no obvious cause of action for compensation. There are jurisdictional issues in terms of where this took place. Each of the companies will, at least up till now, claim that they were not responsible in a sort of direct way for the deplorable conditions of a supplier. This is why the Accord is such an important development prospectively, because it creates for the first time a buy-in from the retailers that they can take some responsibility for for the status of working conditions. Having said that, the liability provisions of the Accord are not open-ended themselves. I mean, there isn't anything in the Accord, as I understand it, that would generate a cause of action for compensation if something were to go wrong. But there are certain aspects there's $500,000 a year over 5 years as a maximum that each signatory is contributing to make sure that standards, capital improvements, inspectors, whatever else, is adequately covered. And that's itself pathbreaking.
Yeah.
This is for whoever on the panel wants to address it, and that is, to what extent is direct consumer pressure an effective vehicle for the upgrade of labor standards in the global supply chain? So I'm thinking more generally, after the New York Times did articles on Apple, there certainly have been reports that working conditions at Foxconn have improved. And that's in part because the consumers who Apple wanted to reach were sensitive to those issues, and so Apple was essentially trying to, maximize profits, as it were, protect its brand by insisting on insisting on change for the upstream supplier. And so, in the same way, I wonder in the retail space if you think enough effort has been brought to create a brand or a trademark or certification that's widely known among consumers, many of whom might be quite sensitive to this. If we can persuade people only, if they're consumers who care about fair trade coffee, then presumably even a much larger fraction might well care about, fair trade garments, as it were, or at least that's the hypothesis. And so I wonder to what extent you think the consumer forcing strategy has been adequately pursued in trying to address the sort of the issues that have come up each of you have addressed through alternative sort of legal ways.
I think that one of the key phrases you used was a widely known certification, and a big problem in this area, and with any consumer movement or latent consumer boycott campaign, with latent possibilities of withdrawing purchasing power from a company that isn't so certified, it is, there's a great deal of information asymmetry here, and in getting to consumers information that's accurate and that consumers can and should trust. There's also a coordination problem, right? Consumers say in polls in the US and surveys, 80% of consumers say, yeah, I'd pay an extra $1 on a $20 t-shirt if I were assured it was not made in a sweatshop. But you go into the store and, can you rely on other consumers to do the same thing that you're about to do, or will everybody else free ride, and will you be the sucker for paying the extra $1? Now that's not necessarily going to deter somebody who's an ethical consumer, right, who cares themselves about whether they're wearing a garment made in a sweatshop, but it will affect consumers who are ethical consequentialists, right, who want to actually have an impact, but they can't trust other consumers. So consumer movements are difficult to sustain. There's also a problem with consumer movements in this area, which is it's hard to target remediation in a surgical way, or in a way that a legal system can. So, you hear a bad report about some Nike factory in India, and so some people withdraw their purchasing power, but then you hear it was remedied, but there are other factories where conditions are not so great. It's hard to calibrate consumer purchasing or withdrawal of purchasing in a way that gets at effective remediation. And these problems are reflected precisely in the case of Apple, because Apple said we're going to do the right thing. It chose a monitor and that, in my view, is not a very good monitor. But the public doesn't know whether the Apple monitor is trustworthy. There was, in fact, immediately a follow-up story in the Times intimating that this monitor was not so great, because the head of the monitoring agency put out a statement saying, oh, everything's all right at Foxconn, it's just the workers are bored. That's why 45 of them committed suicide by jumping off and everything's fine. So the idea that you issue fact-finding before you've done an inspection was not so comforting. So it's hard for consumers to tell the difference in a field where there are competing monitors. So there are information problems at various levels, and you would like to think it would be great if we had one trustworthy website that folks could go to that gave reliable information about which are the better monitors and which companies are submitting themselves to more robust monitoring. But so far we don't have that, and I'm not very confident that we can have a kind of sustained consumer attention that would be necessary. Although it's worth it to do everything we can to amplify consumer attention and involvement.
Yeah, I guess I would add one sort of other cautionary note, although I think this is more it's something we should be spending more time on. The cautionary note is that the industry itself, in terms of where retailers source from, they source from hundreds of factories. They may have 2 or 3% of the business in those factories. And so, assuming a company decides that it actually wants to produce a human rights friendly brand, as one major company has, it will need to concentrate that production in 1 or 2 factories that it has sufficient control over, rather than deal with the 150 factories that it may be sourcing from around the world, most of which it doesn't have sufficient control over. So you end up with a set of choices. If you're going to do this in this industry, there has to be a way to concentrate production and the vertical chain more than has happened to date. And there are proposals to try to do that. And as I say, there's one company that is taking the initiative and asking, not surprisingly, it's targeted at university apparel rather than apparel generally, because students tend to be more willing to say they'll spend $5 extra for a t-shirt or a sweatshirt if they really know that it is produced in a human rights friendly way. Whether that can be broadened to Walmart consumers is a whole other challenge.
Okay.
And it's Teresa's organization that has developed this alternative model along the lines that Jim has just mentioned. And I wish we had time to talk about the designated supplier program, but we've been getting frantic signals for the last 5 minutes. So I think I will have to just thank Jim and Teresa for their wonderful presentations, and